Good afternoon. We welcome this afternoon Professor Brandon Garrett from the University of Virginia Law School, which he joined in 2005, according to you.
It's been 10 years.
10 years. After Columbia, where you did a doctorate, yes? JD, yep. And Yale. And your specialism in teaching and research now is criminal procedure, civil rights, and corporate crime, which is what's brought you to the Political Economy and Financial Markets program. Yeah, and we've been here, particularly under David, been paying more and more attention to corporate governance. I think that's fair to say, especially because of the scandals surrounding the 2007 to 15 financial crisis. I chose 15 very carefully. I still think this is a problem, and I think this financial crisis is an ongoing thing. It's not over, but that's a different question. You published last year this book, which has been widely cited and widely acclaimed, Too Big to Jail. Now, having read it, it is, in the past few days, it is fascinating. I first got involved in corporate governance issues in about 1975, when 73, when the Bank of England started trying to persuade institutional investors in London to set up ginger groups to improve the corporate governance of ginger groups, being institutional investor groups, prudential, life assurance companies, pension funds, to encourage them to get together and try and improve the governance of major corporations who were in difficulties. This initiative followed the near failure, well, it actually was the bankruptcy of Rolls-Royce, which gave the British financial system and the British establishment a bit of a shock. You arrive here at a particularly interesting moment in US-European financial prosecutorial relations. Last week we had the US taking an initiative in relation to FIFA. We also had a movement, I think a prosecutor launched a case. We had the case against an individual, Tom Hayes, for manipulating LIBOR, which is the first major prosecution of an individual in the British situation. What was interesting about that, as I understand it, is that the Department of Justice was about to launch that case and the British authorities preempted it, which is quite an interesting and controversial move. And then the previous week, I think it's 5.6 billion of fines were paid by 6 banks following indictments by American prosecutors for manipulating the foreign exchange market. So we've seen the role of American prosecutors spreading even more assertively across the Atlantic. And this comes out very strongly in your book, and we're looking forward to your explanation of why.
Great. Well, thank you so much. It's a pleasure to meet you. Wonderful to be here. I'm now just about midway through a 3-month stay here at Oxford. It's been my first time. What I wanted to do this evening was to basically give you a walking tour of my book, and the example that I wanted to focus on during the talk is the investigation and prosecution of HSBC, since I thought that would be a familiar company. Now in the news again as of today, because apparently some of the FIFA bribe money may have been sent through HSBC accounts, and so they're doing their own due diligence on that. So along the way, what I'd like to try to explain is just how corporate prosecutions work in the U.S., since they both in terms of the legal standards and then the actual practice on the ground, they work in a way that is unique and explains to some degree why the cases being brought in the U.S. have been such significant ones. So maybe I'll stand up. The title of my book, Too Big to Jail, I thought it was a original and clever name at the time, but maybe not so much. Lots of people have been using that phrase over the last couple of years, well before my book came out. So hopefully maybe people think they know what they mean by the expression now. But what I wanted to capture was that it is not straightforward to criminally punish an artificial entity, and that prosecutors take into account other considerations, since corporations literally can't be put into jail. They can be fined and prosecutors can do other things to them, but the more typical form of punishment in the U.S., jail, is simply not on the table when you're talking about an artificial entity. So, well, I need to get to the beginning of this. Here we go. For some reason it's at the end of the presentation, not the beginning. So let's go to the beginning. I think it was because during the setup process it got moved. Okay.
Yeah.
There we go. So, this fellow was called in to testify in front of the United States Senate a few years ago. He was a compliance officer at HSBC, and this is what he said when he opened his remarks. And it was a permanent subcommittee on investigations chaired by Senator Carl Levin, who has left the U.S. Senate, which is too bad because his investigations really produced an enormous amount of public information about major corporate scandals. So here's what he said.
As I have thought about the structural transformation of the bank's compliance function, I recommended to the group that now is the appropriate time for me and for the bank for someone new to serve as the head of group compliance. I have agreed to work with the bank's senior management towards an orderly transition of this important role. Thank you for your time. I welcome this opportunity to answer any questions.
Short and sweet. So he quit on the Senate floor. That's not something you see every day, but it's certainly one way to face the music when you're expecting tough questioning from a subcommittee on investigations. He said, I hereby quit, in a very polite way. He also noted, though, that he thinks that perhaps with the benefit of his absence, that the bank was well on its way to turning a new leaf. The bank has learned from its past and already is on a path to becoming a better, stronger banking institution. So that was his testimony. What came out initially through this investigation by the Carl Levin's subcommittee, and these congressional committees in the U.S. have subpoena power. They demanded and received over 1 million pages of documents. They found every kind of banking violation practically that one could find. They found one focus of their investigation were transactions having to do with Mexican drug cartels. And drug cartels, if you're a drug cartel leader, you have a problem in that you have a heavily cash-focused business, and you have to do something with all that cash. It's not easy. They found a helpful partner in the Mexican subsidiary of HSBC, which apparently they were designing cash boxes to the specifications of the teller windows of this HSBC-owned bank. Now, HSBC had bought that bank in the early 2000s when they were doing a major expansion around the world, and the bank that they bought was one that was known to have serious money laundering compliance problems. It had been the subject of a money laundering sting in the United States in the late 1990s. I think it was Operation Casa Bianca or something like that. And so it was known to have serious problems and to be a favorite of drug cartels. But HSBC bought it anyway and didn't do anything to change the compliance on the ground at this bank. So hundreds and hundreds, they identified over $880 million in drug proceeds that went through that bank, but over $15 billion went through that bank during the relevant years, and it wasn't clear how much of that had to do with drug proceeds, but enormous amounts of cash were flowing in and through that subsidiary. $880 million is probably a small number, actually. That was just one subsidiary, and some people had talked about the HSBC investigation as being about a bad subsidiary that they just happened to have the bad luck to purchase. However, there were also this whole range of transactions also in the tens and hundreds of millions flowing to different banks and entities that were linked to international terrorism. Then there was a whole other set, a whole third set, depending how you count these things, of transactions to sanctioned regimes. Now, Cuba would be off the list now. That would be okay, as of this last year. But Burma, Iran, Libya, North Korea, Sudan, basically every troubled regime around the world with which banks were not permitted, if they meant to have a presence in the United States, and HSBC had two large subsidiaries that they had bought in the United States. Huge transactions were flowing to all of these sanctioned regimes around the world. So basically money was going to all the places where it was not supposed to be going in lots of different ways. And then the question was, well, why was this happening, and why was it happening for so long? The documents had just wonderful emails, and the Senate committee did a nice job of flagging some of the particularly stunning emails. But what was most troubling to observers was that there had been, maybe not the compliance official who quit on the Senate floor, he didn't seem to display much in the way of awareness or remorse. Prior compliance officers, though, had raised serious complaints at the time about the lack of the compliance function. Our OFAC process is in disarray and in great risk of being non-compliant. There is no recognizable compliance or money laundering function. Back in 2002, a decade before. We are in dire straits right now. It was a tiny compliance office, and not much more than 100 people for this major global bank. And so people complained and said, look, we can't do our jobs. We don't have the staff. It doesn't seem to be our priority. And their supervisors basically conveyed to them, it's not a priority. And compliance officers were fired for sending emails like this complaining, until ultimately the compliance officer publicly quits. So there was a fair amount of internal awareness that it was a shoddy operation. But then how about the regulators? The American regulators at the OCC, whose job it was to supervise this, was apparently not being done in a particularly great way either. It sounds like the OCC examiners thought HSBC had serious problems, but they felt like their supervision of banks was limited to certain boxes that needed to be checked. Is there a compliance function? Do they have a policy on money laundering? It sounded like they felt like their job wasn't to actually examine the quality on the ground of the compliance function at major banks. And so the regulators really weren't doing their jobs and didn't feel like they were supposed to do much of anything to carefully scrutinize major banks. So prosecutors stepped in. And Carl Levin later said that, this is the situation where you most want the criminal authorities to step in, where the civil authorities, the regulators, clearly haven't been taking this problem seriously, and therefore it's festered and reached a very, very serious level. Now, here I have some explaining to do. I need to pause on this, although it's hard to make sense of a long agreement. It was the only way I could fit it into one square. And so it's a word cloud. It shows what words were repeated a lot, and a lot of generic words were repeated a lot, like the names of the parties. What this agreement was a settlement agreement between the prosecutors and the bank, and that's sort of what it looks like. It's a kind of settlement agreement, though, that has only existed on paper as a possibility in the UK for the last couple of years, modeled on this US approach. And it's the kind of agreement that never would have been entered with a corporation in a criminal case, really prior to the last decade. So a deferred prosecution agreement, what is that? Well, normally in the US, when people are prosecuted, they are indicted, or there's information, and then they are convicted. Same for individuals as for companies. Criminal trials are disappearing in the United States, so typically when people face serious criminal charges, they plead guilty. And they might sign an agreement like this, accepting responsibility, maybe including some terms as to the sentence, or maybe leaving sentencing to the judge. The judge will review it, ask the person if they understand the consequences of pleading guilty. There will be a hearing going over the terms. The person is then sentenced and convicted. Now, some individuals go to trial, some corporations go to trial, not very many. Trials are, most cases do settle in the U.S. criminal justice system, including the federal system. But they don't normally settle like this. A deferred prosecution agreement is an agreement that doesn't involve any criminal conviction, no criminal record, and no indictment. Its origins were in Brooklyn, and actually this agreement was also entered in the Eastern District of Brooklyn. The U.S. attorney at the time was Loretta Lynch, who is now the U.S. attorney for the United States. Apparently she was asked one question about the HSBC case during her confirmation hearings. They were interested in other things, I guess. But in the 1930s and 40s, there was something called the Brooklyn Plan, which was something quite new in the federal system, where diversion or deferred prosecution agreements were entered with low-level juveniles or first-time drug offenders. And the idea was, we will file a case against this person, but they're so low-level, we'd like to rehabilitate them. It's one thing to rehabilitate people after they've been in prison, but it's harder to rehabilitate someone once they've been through a prison experience. These are such low-level offenders that we are not sure they even deserve to be in the criminal system at all.
It's a bit like a caution.
The same idea, yeah. And so the idea is we are filing something, but we're entering an agreement with you where we will basically stay the proceedings. It will remain on the judge's docket for a year or 2 years, but assuming you show good conduct, the case will be dismissed. And with drug offenders, maybe there would be conditions including taking drug tests, or you'd have to report every 6 months, or sometimes it's more informal than that. If you don't get in any trouble over the next year, the charges will be dismissed. And there are some more formalized diversion programs in drug courts or specialized courts in the U.S. There are no formalized diversion or deferred prosecution programs in the federal criminal system. Maybe because federal prosecutors think they only bring the most serious cases. We don't take low-level stuff in the federal system. And so deferred prosecution agreements had not been really much used by federal prosecutors at all for individuals. And the idea of extending this deferred prosecution concept to corporations in the most serious criminal cases, that was a creative move. It was not something that had ever been considered really before. There had been a few examples of this in the 1990s that I've discovered, a few sort of odd examples. And the practice only took off starting in 2003. And what had happened was that the year before, Arthur Andersen was prosecuted. Arthur Andersen was offered a deal to avoid a conviction because everyone understood that if Arthur Andersen was convicted, the SEC might revoke its license to do accounting work for public companies, which would be the death of Arthur Andersen as a Big Five accounting firm. Arthur Andersen thought about accepting such a deal, but the SEC actually wasn't going to make any promises, even if they received a deferred prosecution agreement, including because Arthur Andersen was under investigation for so many other accounting mishaps, waste management, Sunbeam. Arthur Andersen was in so much trouble, and they were already under an SEC decree, which they had arguably violated. So the SEC basically said, we can't make you any promises. Because of that, Arthur Andersen said, well, without any promises, well, let's risk a trial. They risked a trial. They were convicted. They received a $500,000 fine for shredding lots of documents related to Enron. The fine wasn't the big deal. What was a big deal was that they were suspended then by the SEC shortly after they were convicted. The conviction was later reversed on appeal. That's a whole other story that I talk about in the book. But having been suspended by the SEC, Arthur Andersen sort of dissolves. Although it still exists legally and runs a conference center outside Chicago, which mostly serves as a funding stream for the people that they owe money to. Within a year of that, federal prosecutors basically wanted to regroup. There was public criticism. You destroyed this good accounting firm based on the deeds of a small group of employees. I'm not sure that story really accurately conveys what was going on at Arthur Andersen or what the criminal case was about. But be that as it may, the prosecutors issued a new memo, which I'll show you some of the terms of this memo. And the memo didn't say, give the biggest companies deferred prosecution agreements and don't bother to prosecute them, don't bother to seek convictions. It didn't say anything like that, but the tacit message seemed to be, and when I've talked to prosecutors, they've agreed, the tacit message seemed to be, you need to tread more lightly when you're prosecuting the biggest companies. So it's interesting, actually, it's not like the small, low-level companies get these like low-level individuals would. It's often the biggest companies, the public companies, the ones that may be most reputation sensitive, started to receive these deferred prosecution agreements. And the terms of these agreements are easier to see listed. So here are the terms of the HSBC Deferred Prosecution Agreement. They had to admit their guilt and accept responsibility, which actually a company that pleads guilty would have to do. There's been some criticism of civil agreements that the SEC had entered, where they would say we neither admit nor deny guilt. There would be a non-admission of guilt. And actually Barclay has negotiated something like that in the LIBOR case. They accepted responsibility and admitted guilt for the facts described in the statement of facts, but they didn't actually admit to a particular crime. I'm sure lawyers billed, hundreds of thousands of dollars negotiating that particular line of the agreement. They paid an enormous criminal forfeiture, close to $2 billion total. And this agreement would last longer, actually, than average. Typically, these agreements last about 2 years. This one would last 5 years, and so the clock is still ticking on this particular deferred prosecution agreement. It was a 5-year agreement with a corporate monitor, a person who would be appointed to oversee the new compliance program. And so the compliance officer had quit. There would be a new compliance department, new staff. The agreement described in some detail what these new anti-money laundering programs and sanctions compliance, what all the different wings of this compliance policy would look like, what the new policies would look like, what the new staff would look like. There's some real detail about the governance changes that HSBC would have to make. The agreement even included some language about the need for clawbacks, so that executives would have to give up their bonuses if they were found to have participated in non-compliance, whatever that means.
It's deferred. Is there ever actually closure?
Yeah, so at the end of the 5 years, the parties typically go before the judge and they say, we are satisfied that everything has been completed satisfactorily. The case is dismissed from the judge's docket, never having moved forward. And so the case basically remains on ice. It never moves. The speedy trial clock is told, and that's actually the statutory provision that permits this. Normally cases can't just remain suspended like this. There's a speedy trial right. HSBC formally waived its right to a speedy trial. There is a provision in the Speedy Trial Act which says that prosecutors may ask that the speedy trial provisions be waived with the agreement of the defendant and the approval of the judge. And so the judge had to approve this, and ultimately did, although I'll talk about that a little bit more too. The agreement also described new staff at HSBC, although some of it wasn't, very little of it was by the way of requiring HSBC to create new positions. Mostly the agreement sort of praised HSBC and said one of the reasons why we're giving them this lenient treatment is that they have made all these sweeping changes. There's a new CEO, there's a new chief compliance officer. We believe that they are turning over a new leaf, and that's one reason why we agreed to settle this case in this particular way. The agreement also includes terms that require cooperation. Cooperation broadly stated: in any pending investigations, HSBC shall cooperate by providing documents, making available employees for interviews with prosecutors, any investigations related to the subject matter of this at least. HSBC also promises in the agreement not to engage in any further federal crimes. And if they do so, that could be a material breach of the agreement, which could mean that the agreement would be revoked. Prosecutors could then take advantage of all of HSBC's admissions in the agreement and the waiver of the speedy trial clock and any relevant statute of limitations and prosecute HSBC. And that would be, one would expect, an easy prosecution, since HSBC had admitted to all these facts and accepted responsibilities. Prosecutors could use that if there was a breach. And there's some other breach terms: if HSBC didn't cooperate, if HSBC committed new federal crimes, if HSBC publicly denied the facts in the agreement. All those things, in the prosecutor's complete and unilateral discretion, can be deemed a breach.
Could you explain what
admission of guilt means?
No
trial and no criminal
conviction.
Conviction.
So it's an admission, but there's no judgment. And so there's a question about what normally party admissions are really subsumed in a judgment.
Yeah.
And a conviction of fraud means that you have been found guilty of fraud beyond a reasonable doubt, and that would be a powerful judgment which could have preclusive effect in future civil proceedings. Now, a party admission like this, the courts in the U.S. have been divided as to what impact that admission has if there's a future civil suit. And so that they have publicly admitted it as a company, and there's a statement of facts, and so it's itemized what facts were admitted. Now, there was no judgment relying on those facts, and so arguably it's an issue which could be precluded in future litigation in the U.S. But the rules on issue preclusion are somewhat flexible, and there's a real question about whether these are issues that were necessarily decided as part of any decision that had to be reached.
Yeah.
The settlement agreement itself doesn't say anything about, we agree to be civilly liable based on these admissions. They just say we admit it, and we acknowledge responsibility for it, which means nothing more than what it says. I mean, they feel bad. They acknowledge responsibility.
Yeah.
That's really language borrowed from the guilty plea
Does
context.
it open them up to civil suits on the basis of this, or are they protected?
Potentially. In the agreement, sometimes say you shall not publicly deny in any way the things that you have admitted in this agreement. And so, in a civil suit, they can't deny, for example, that $880 million, went to the Mexican bank, or that they didn't have a compliance function. But the civil lawyers would probably lose if they tried to argue HSBC admitted it committed a crime. They admitted they committed fraud or whatever. They have admitted that they committed the legal elements of a crime. That would probably not fly in a civil case. But particular factual findings, particular facts that they had admitted to, they might be able to sort of rely on those in a civil case. And often there are civil cases filed where a deferred prosecution agreement is Exhibit A attached to the plaintiff's complaint, the first document that they rely on. Since it may be hard to get public information about what was going on inside a corporation, in the absence of such an agreement, these agreements are frequently used by civil litigators, sometimes successfully, sometimes not. But they may just use it to provide factual information, facts that they know that the defendant can't deny, but they aren't normally admissions that can literally bind in a future civil case.
But is there any effect in there being criminal forfeiture? I mean, I can see the run through to civil, but you're actually in the midst of all that, you've got criminal forfeiture, which doesn't that bring in a different aspect which could be used later against them?
Well, the fact that again, they haven't exactly admitted to the elements of a crime.
Money on the basis of
They've paid a lot of money on the basis of it. Also, because the money is denominated as a criminal forfeiture, or in some of these cases it's denominated a criminal penalty, that will typically mean that it's not tax deductible. So that can be quite important. That changes the amount of the fine quite a bit. The atmospherics are certainly affected by this agreement being criminal and not civil. But there are certainly some crimes where there is no civil right of action in the U.S., and so many companies, I'll show a little bit more in a minute, pay big fines over foreign bribery. Maybe FIFO will, or officials at FIFO will. There is no civil action for payment of bribes to foreign officials in the U.S., and so there is no civil consequence to admitting that one has violated the Foreign Corrupt Practices Act, which criminalizes foreign bribery. Now, if there's fraud that affects the stock price, typically private, there'll be shareholder suits in the U.S. Some of those succeed in these cases, some don't. it really depends on the type of crime whether a civil suit can be filed. And I'll say a little bit about this, but in some of these cases, actually, prosecutors are the ones who, in a package along with the criminal case, set up a victim restitution fund, and they compensate the civil victims really through the criminal case, and so it's all done as part of one vehicle. And that makes things confusing too, because there can be multiple types of cases all being brought at the same time, accomplishing a mixture of civil and criminal goals. So this is just to give a sense of how the size of these corporate criminal cases has exploded in the United States. Before 2009, no one had ever seen a $1 billion corporate prosecution anywhere, including in the United States. And $1 billion fines have become normal. There were multiple $1 billion fines announced a few weeks ago when the Forex cases were settled. This year will be much larger. 2015 will be much larger than any of these years because the BNP Paribas guilty plea was formally entered and resulted in sentencing just a month or two ago. And that involved, almost $9 billion. Although some of that was, maybe $6 billion of it was to federal prosecutors. That plus a couple $1 billion paid by Credit Suisse, plus the $5.9 billion in these Forex investigations. We are in, more than $10 billion just in those handful of cases in 2015. What the colors are supposed to help to illustrate are that the particular types of corporate prosecutions that are important vary somewhat wildly each year. Really, the only color that is somewhat steady state over this entire time period is antitrust. There's much more stable cartel enforcement, antitrust enforcement in the U.S., and there has been since the late 90s when international cartel prosecutions first became important in the United States. There have been major antitrust cases brought every year, and that seems to be steady. Whereas some of these other types of prosecutions fluctuate wildly, and what makes a year look like a really big year for corporate prosecutions may just be 1 or 2 cases. These days, maybe they're 3 or 4 or 5 or $6 billion cases, but in the lead up to 2015, at least, 2013 looks like an enormous year for environmental prosecutions, but that was because of the BP settlement regarding the Gulf spill. That was that entire red area is all the BP settlement, and that was nothing compared to the civil payments in that case. And actually, a lot of that was fascinating. It was the biggest community service payment in U.S. history. There were several $1 billion in community service payments so that scientists, including at the National Academy of Sciences, the Coast Guard, could study the Gulf. The 2009 was the first $1 billion case. It was a settlement with Pfizer over off-label marketing of pharmaceuticals. And you can see there have been a number of these big pharma cases in orange. There's GlaxoSmithKline. There's just about every year since 2009, there's been one or another really big pharma settlement. And some of these Bank Secrecy Act cases involving banking compliance, anti-money laundering have become increasingly important. The HSBC one is right there. So there have not been, however, more cases brought against corporations by federal prosecutors. It's just that the big blockbuster cases have gotten much, much bigger on a scale that we really hadn't seen before. This just shows just that the financial institution prosecutions, I'll need to add several 2015 cases to the top of this list now. You'll also notice that it's a range of different crimes. Banks aren't all prosecuted for the same things. HSBC happened to mostly deal with sanctions and anti-money laundering. But some cases are purely sanctions, some tax violations. We may see, well, maybe even more than 200 non-prosecution agreements with Swiss banks that were offered amnesty if they came forward. So there's a lot of Swiss banking activity in this area. Other cases involving different types of frauds.
Is there anything to be read into the fact that 4 of the 5 bolded entries at the top, the biggest ones, are foreign corporations? It can be in any.
So, my next slide. Average foreign fines are much larger. controlled for a few simple things. There are a lot of things that one cannot control for, but I did control for whether the firm was public and what the type of crime was. There are certainly types of crimes which tend to involve much bigger penalties. But even controlling for whether the company was public or not and the type of crime, the foreign fines were far larger on average. And that it's not just limited to financial crimes or banks. The cases involving companies that are not based in the U.S., foreign companies from a U.S. perspective, are just much bigger on average. Now, there are a lot of explanations for that, and I talk about it some in my book. Some prosecutors have told me, look, it has nothing to do with the fact that the company is foreign or not. It's just that to get jurisdiction over foreign companies, they tend to be public companies. That tends to be the jurisdictional hook. The cases that we bring against public companies will be bigger. Of course, I did control for whether the companies are public, and when I mention that, they say, well, but there's another feature of this, which is that we're not going to bother prosecuting a foreign company unless it's a really significant case. There's so many practical obstacles. It's hard to extradite individuals. It's hard to get information in the United States. We have lots of prosecutions, and you can see them in my websites of mom and pop type, a garage for violating environmental rules. Some of those wouldn't be brought by federal prosecutors, but plenty of minor frauds, minor money laundering, minor environmental violations by just family businesses. You're not going to prosecute a foreign family business. It will tend to be the really big ones that catch U.S. prosecutors' attention. So that's explanation number 2. There were other explanations. The third explanation that prosecutors give in particular areas is that some of these foreign companies are just simply more egregious violators than any U.S. company would be. They may just not be aware of U.S. law. They may think that they are outside U.S. jurisdiction. The BNP case is a case in point where the bank absolutely was not cooperative with U.S. prosecutors. It didn't think it needed to cooperate, and it had been violating sanctions with Sudan on a grand scale for some time, maybe because the French government said go for it. And there's another piece of that, which is, of course, it may not just be that a foreign company may be less familiar, understandably, with U.S. law, but a foreign company may be less familiar, understandably, with the way these cases get negotiated. And so you see some cases where there's a settlement, a deferred prosecution agreement with Alcatel-Lucent, another French company, where they were non-cooperative for a couple of years, and then they realized, this isn't going so well. They then hired a big American law firm which knew how to negotiate these cases, and all of a sudden they got credit for being suddenly very cooperative, and they're doing all the right things, and they receive a deferred prosecution agreement. There's the final explanation, which is the least favorable to the ethics of these U.S. prosecutors, and that's they're more comfortable targeting foreign companies and making them pay lots of money. Maybe they think it levels the playing field for U.S. companies, and it helps the U.S. Treasury. Maybe they really are more aggressive with foreign companies. There's no way that these results support one explanation more than another. But certainly angry French journalists after BNP was prosecuted cited this figure and said, see, these American prosecutors are singling out foreign companies. I'm not sure I can speak to that with this data, but there have been an enormous number of very, very big cases brought against foreign companies. There's no doubt about that. This image illustrates how the fines that are denoted as sort of punishment are only one small part of the picture. There's also restitution, which goes to victims. Some of these cases involve victim compensation. That tends to happen when there are identifiable people who were victimized. If there's a fraud and shareholders can be compensated, if it's an environmental disaster and business owners or people who are poisoned or affected by a toxic spill, if they can be identified, they can be compensated through the criminal judgment itself and not just through a separate civil suit. There was many billions of dollars accompanying these agreements in private civil suits as well, and those are just the ones I could identify. I tried to do whatever legal searches and news searches. Plenty of civil settlements in the U.S. are confidential between the parties, and so one doesn't know how much money was involved. So there's some cases where I know there was a civil suit, I know that it was resolved, and I don't know what the money is. So it may be much more than that. And quite a bit of money, far more than was paid in fines, was paid to regulators. And so paid to the Office of Comptroller of the Currency in the case of the HSBC case, or paid to the IRS in the case of tax prosecutions. And so these cases are accompanied by multiple types of payments. This is just to illustrate what I said before, which is that these agreements are chiefly entered with the biggest and most important companies, the companies that we're most interested in, the public companies. Many of them are Global 500, Fortune 500 companies. Many of them are prosecuted through the Department of Justice itself. And so there isn't a big story here of rogue U.S. attorneys' offices around the United States doing these their own way. There's a fair amount of central oversight, although not completely. Some of these cases are brought by particular U.S. attorneys' offices, which do operate somewhat independently of the main Department of Justice in Washington, D.C. Many of these cases, like one would expect, are brought in the Southern District of New York, which has always had the biggest fraud and financial crimes type unit.
If you were to add a variable Benjamin Lawski to your regression, would that affect the?
Well, he's a state prosecutor. He's the New York State banking enforcer now. And it was interesting, right? Cuomo clearly wanted to weaken the office of the New York Attorney General, and so they separated some of the financial enforcement from the Attorney General's office. And I don't think anyone thinks that weakened the enforcement function in New York. Now you have Lawski and you have an Attorney General. A lot of these cases are New York cases, and Lawski has insisted on certain things, which may have resulted in more stringent settlements. That's really, we've only seen that in the last couple of years.
He just resigned last week.
Lawski resigned last week? Really?
Yeah, he's going into private practice.
Oh, interesting. See, I'm out of touch. I was traveling with the kids because there was a school break here, so I missed that. This is just to highlight that most companies are still convicted. It's not the raw numbers. It's that most of the public companies receive these deferred and non-prosecution agreements.
Huh.
So you can see how starting in 2003, public companies begin more often than not to receive these deferred and non-prosecution agreements. Some are still convicted. And those banks that pleaded guilty in the Forex settlements announced a few weeks ago, those are companies that will be convicted. So there are still plenty of convictions. But many more of these prosecutions of public companies are resolved largely out of court. I should note that non-prosecution agreements are even more out of court than deferred prosecution agreements. For some time, banks would almost exclusively receive non-prosecution agreements. And with non-prosecution agreements, nothing is ever filed in court. There isn't even a judge saying, oh yes, I'll let this stay on my docket for 2 or 3 years until you dismiss it. A non-prosecution agreement is basically, we agree to not even prosecute you. We will not file anything in court. We will not even file a complaint or seek an indictment, assuming you do these things for 2 years and pay a fine and hire a monitor. So it has a lot of the same terms, but nothing is ever filed in a court. And so there is no possibility of a judge even setting eyes on the agreement. Some of those agreements were harder to find. Some had been sealed and not made public. Not sealed by a judge, but just never shown to anyone. And actually our clinic, we have a First Amendment clinic, and I'm not sure what this has to do with free speech exactly, but they had, with my encouragement, sued the Department of Justice to get those agreements, and the Department of Justice agreed to settle the case a couple of weeks ago. And so there were about 20 agreements that no one had ever seen before that we finally obtained. It's still not clear to us why they were sealed in the first place or what the rationale was, but now we have them. I should also note that all of these agreements are available online. And
the agreements are, but is the evidence that was used to come to those agreements also available?
Well, so there had been no place there had been no one place to figure out how prosecutors were prosecuting companies, and so the beginnings of this project, which led to this book, where I guess I started looking at these carefully in 2005, 2006, when all of a sudden you started to see deferred prosecution agreements creeping up, and more of them were being entered against public companies. I started to think that this is something worth tracking, and I wrote an article about it early on. Accompanying the article, I thought, well, there had only been maybe 30 or 40 of these deferred prosecution, non-prosecution agreements at the time. I put them up online as a resource page, figuring if people wanted to read what I was writing about in the article, there was a place to find them. Now, occasionally prosecutors would post an agreement online along with their press release, but there was no information about them. And unlike guilty pleas, where there's a hearing in court, one can see the filings through legal databases. The Sentencing Commission collects data on convicted companies. This was sort of a black hole where sometimes prosecutors would announce these things and circulate them, sometimes they wouldn't. It was hard to get information about this emerging practice of settling these cases largely out of court. And so I've been maintaining that resource website ever since, and we had to sue to get some of the agreements. For the most part, we would call U.S. attorneys' offices and they would send them. They were typically proud of what they negotiated with the company. These were significant cases. And so that was the beginnings of this. I separately wanted to find out information about convicted companies, and there are many more of those. There have been over 300 of these deferred and non-prosecution agreements. During the same time period since 2001, there have been 2,500 or so convictions of companies, most of them insignificant, small mom-and-pop type prosecutions. But I didn't trust the Sentencing Commission's information, since they certainly didn't have information about these deferred and non-prosecution agreement cases. The fines that they were reporting in any given year didn't seem like they were right. They seemed too low. And so basically I reconstructed the entire universe of convicted companies as well, and I have a large website with all those guilty pleas and related documents. Now, what I have is the documents that were either public or that were entered between the parties and that I made public that reflect the agreements between companies and prosecutors, sometimes some additional documents reflecting agreements with regulators, or docket sheets reflecting the steps that occurred in the case. What the public never sees are the information that caused prosecutors to bring the case, or what they were relying on to reach the decisions that they reached. All one can read is what is contained in these agreements, which explain this is why we gave the company a deal, this is the statement of facts. But that was the origins of this. I noticed this odd practice and started just acting like a pack rat and collecting agreements and making them public really as a resource. And then as more and more alumni started emailing me saying, this is great, keep this website up, you need to update it, here's an agreement that you're missing, I started to spend more and more time working on it. Also, actually, the research librarians at the University of Virginia really got into this. I think they like the idea of having a digital collection. They received lots of happy thank you emails from lawyers, and they started to get lots of web traffic. Although what was really embarrassing is that since then I've started to talk to some prosecutors, including in the Southern District, who say, oh yeah, we use your website all the time. It's really useful because when we're writing up an agreement, we want to look at another agreement to copy from. And I thought, oh, you should know what you're doing. You shouldn't need to copy boilerplate from stuff on this website, but apparently they do. This was the memo that shifted the practice in 2003. These are the main factors. And so one thing that I should also stop to explain is that federal prosecutors in the U.S. can take advantage of a legal standard which doesn't exist anywhere else in the world. And it dates back to a 1909 U.S. Supreme Court case involving a railroad that was setting illegal rates, which endorsed such a rule. The rule is a Respondeat superior standard. So if there is a single agent working for a company in the scope of their employment, doing something that in some way benefits the company, that commits a crime, then the company is responsible. So it is a derivative form of liability. No one is saying that the company is itself morally accountable, but the company is derivatively accountable for the crime of even a single employee. And so that's a very broad, strict standard. It's not strict liability, but it's Respondeat superior. It doesn't take much to show that an employee was acting in some way in the scope of their employment. Now, so that's what federal prosecutors can do in theory to hold the company accountable. In practice, they don't prosecute every company where someone on the job commits a crime. There's typically little purpose in doing so, but there hadn't been factors explaining, well, when do you decide to bring the case against the company as well? Or when do you just prosecute the employees and try to put them in jail? This memo began by describing how, and it was an update of an earlier memo authored by actually Eric Holder when he was Deputy Attorney General in the late 90s. You look at basically the corporate culpability. Was this a serious offense that implicated a lot of people? If it was a few rogue employees, then just prosecute them, don't prosecute the company. Did this company have a history of doing similar things? Or was the wrongdoing, was it at multiple levels of the company? Did it reach higher ups? And so there's a memo that describes those factors and sets out how you should think about the culpability of the company. Does it seem like it's a company that's itself blameworthy? If it's just a few employees, then there's little added purpose in prosecuting the company. The second set of factors in red has to do more with the company's behavior towards the prosecutors. So did the company self-disclose, self-report the conduct? Prosecutors care about this quite a bit, and they should probably care about it quite a bit more. Some corporate crimes will never be learned of publicly unless the company reports it. Now, some things are out there in the open. The Gulf spill was easy to detect. Maybe there was some lack of candid disclosure as to the, how many millions of gallons were flowing, and that's in part why BP was prosecuted, but it wasn't a secret that a disaster had happened. Now, some of the conduct fixing the LIBOR rate, if some of the whistleblowers and banks hadn't come forward and disclosed that, it might never have come to light. The nature of organizations is that information sometimes doesn't travel upstream to higher ups the way it should. Sometimes it certainly wouldn't necessarily travel to law enforcement. Prosecutors also put a lot of emphasis on the existence and effectiveness of compliance programs. Did the company have measures in place to try to detect this kind of thing? Was it rogue employees that managed to avoid detection using clever tricks, or was it a company that just didn't care, had no systems in place, and was basically tolerating this conduct? And even if the company had terrible compliance in the past, has it done lots of things to remedy the problem since? Is it showing good behavior now, at least? The final set of factors has to do with really the Arthur Andersen problem. Would we be destroying a company, hurting innocent employees who had nothing to do with this crime if we prosecuted them? What would be the consequences? Is this a company that would be subject to regulatory debarment or suspension if it is prosecuted and convicted? Is that a reason to consider an alternative to a conviction? Would if civil enforcers are already bringing cases against this company, would those fines be enough? Is there any added purpose, added deterrent from bringing a criminal case? Now, there was no particular ranking assigned to these factors. It's a lot of factors. There was no guidance on how you weigh them. It's a bunch of considerations that federal prosecutors are supposed to think about. Now, lawyers working in the major white-collar practices, which have boomed in the years that I described, when the corporate fines have boomed, so is the hiring of former prosecutors and the beefing up of white-collar practices at all of the top U.S. law firms. They will absolutely brief each of these factors to prosecutors, saying, this is why we satisfy factor 2. This is number 6. Let's talk to you about remedial actions. And so these have added some focus to the negotiations between prosecutors and companies, but there's nothing set in stone about them. One concern I had was, well, how about compliance? If prosecutors really cared about compliance, you would think that they would tend to bring cases only against companies that had really weak compliance. You'd also expect them to say some serious things about what the company was supposed to do to improve its compliance. Lots of these agreements just sort of say, do some compliance stuff, basically. Adopt appropriate due diligence. Adopt best practices, without any explanation of what those words mean or what the company is actually supposed to do. Very few of these agreements require that the company actually do something specific to check on how the compliance is going. And if supposedly the purpose is to allow a potential criminal to show good conduct to avoid prosecution, well, one would think that they would actually have to do something more to show good conduct, including by...
agreements? Are they pages and pages or just one page?
They tend to be 15 to 30 pages, and so they have some detail. They aren't so short that one wouldn't expect that kind of detail. They often have separate paragraphs breaking out the particular compliance terms. They will often have a separate statement of fact describing the underlying conduct, although typically without naming particular people that did things. They will say Supervisor A failed to supervise anti-money laundering. Complaints were made to Supervisor B who did nothing. They will tend not to name names. This just sort of distills the terms of these deferred and non-prosecution agreements. One thing that I found particularly troubling, again, was how few of them required any auditing of the compliance. Now, some of them did require that a corporate monitor be hired. So, maybe a quarter of them had appointed an independent person to monitor compliance, and I'll talk about that in a few minutes. A few required specific governance changes, not very many, like hiring a new hire a new chief compliance officer who reports to the board, or in rare cases, eliminate this division. We just think it's that division is no good. Typically,
in Siemens' case, they cleaned out the whole board. Yeah, the chief executive went. I mean,
yeah. Although the agreement didn't require it, they did that on their own. But the agreement didn't say fire your leadership. Very few agreements have said anything about terminating particular employees. They sometimes say, we recognize this company has done extraordinary remedial things, including replacing its leadership. But very unusual for an agreement to actually say you must fire someone. The agreements sometimes say you must hire someone. You must fill a new position called chief compliance officer or called anti-money laundering coordinator or whatever.
5 to 10 minutes.
Yeah. I was thinking 5 or 10 minutes.
Good.
So the monitor in this case would serve for 5 years. In the HSBC case, he was a prominent person, former New York prosecutor, Michael Tchaikovsky, well thought of, and he has been issuing reports as to the progress of HSBC. The reports have not been glowing. The reports so far have all been saying that HSBC has serious problems still. Now, the monitor is an unusual person. The monitor, he is paid by HSBC, but he's a lawyer. Normally, when a lawyer is hired by someone, they are hired by their client, who they owe certain duties to represent. HSBC is not his client, nor is his client the prosecutors. It's a different role for often it's lawyers who are put in this role, where one's duty is to be independent, to gather information, to present that information to both the company and to prosecutors, and to investigate how compliance is going and to make recommendations on how to improve compliance so that it's adequate. It's a very broad and ill-defined function. This agreement did not, but some of the more recent agreements have started to do something which I think is useful. They've started to set out a work plan in the agreement itself, describing the boundaries of what the monitor is supposed to do, the steps the monitor is supposed to take, what kind of team they need. These are highly lucrative positions. Tchaikovsky is undoubtedly being paid an enormous amount at his regular hourly rate. Typically it takes a team of people, sometimes quite a large team of people, to review the millions of pages of documents involved, to talk to employees around the world. When you're talking about a huge multinational bank like HSBC, one person could never keep tabs of how compliance was going at a bank like that.
Isn't that a problem in a way, in that actually they're trying to draw up the Leviathan with a hook?
Yes.
Yeah.
Well, so obviously the prosecutors themselves absolutely cannot have any sense of what's going on in HSBC. In a big case like this, maybe the Eastern District of New York might have assigned 2 prosecutors to the case and not 1. And maybe they would have received 2 FBI agents and not 1. And they have the cooperation of an enforcement counterpart at the OCC and a couple of other regulators. And so, a few chairs can be filled around a small table in terms of the government officials and lawyers who are working on this case. HSBC is they're hiring entire law firms to defend themselves. And the idea is to leverage the resources of the bank. You must hire this monitor who will have a staff, the kind of staff that, as federal prosecutors, we have no access to. And so it was a clever idea. Its origins, judges would sometimes appoint special masters with a staff in complex organizational cases. In some of the big racketeering cases against labor unions in the United States, the judges would appoint trustees with a staff to supervise anti-corruption efforts within a union. Or sometimes if there were cases involving school desegregation or prison conditions, a judge would appoint a master to sort of oversee that operation. And so you have to think of this as basically an institutional reform effort where someone independent needs to oversee it. They're creating, in a way, a mini temporary administrative agency to supervise this agreement.
Could you argue that the big fines are connected with the desire of these prosecuting agencies to enhance their resources so that they have they're in a better position to pursue them in the future.
Well, the fines don't normally go to the particular agency. They may go to the U.S. Treasury. And in fact, during the same time that these fines were exploding, there was a hiring freeze across all of the federal prosecutors' offices. And so the Southern District of New York, for example, was bringing in billion-dollar fines, and they couldn't replace lawyers that left for private practice for 2 years. The hiring freeze has now been lifted, but they absolutely don't see it. The U.S. Treasury may see it. Some state offices don't work exactly that way. So, for example, the Manhattan District Attorney's Office has a really big financial crimes group, much bigger than a local prosecutor's office would have, and they don't directly receive fine money that they bring in, but indirectly the state of New York gives them the kind of staff that no local prosecutor would ever have. And so they bring a lot of white-collar cases, even though they're just a regular prosecutor's office. And now maybe it would actually increase enforcement quite a bit if prosecutors could get a bounty every time they won one of these cases, but they don't see it directly. The Monitor did describe that real changes were made, thousands of employees. It's now more than 1,800. It's getting closer to 10,000 employees were hired at HSBC. The HSBC itself spent hundreds of millions of dollars doing internal reviews, and so prosecutors leveraged resources in that way too. The bank did its own work. Bonuses would now be based on compliance standards and values. And it sounds like there actually have been some clawbacks of major executives' bonuses. Not more than a couple $1 million a year, but there's been some. I don't know why they gave these parrot certificates to employees, but apparently the U.S. staff received certificates with parrots on them. My young boys might enjoy a certificate with an animal on it, but I'm not sure. They made some very high-profile hires, names that would probably mean more to you than to me. Former heads of MI5, things, impressive names were added to the staff at HSBC to supervise compliance. And
700. Go on.
Sorry, just to say that some of those impressive names were seen as sort of like a get the establishment off my back appointments.
That's sometimes why impressive people get high-paid positions, right?
When you said 700 review of clients, that's internal work just to check internally that they are indeed complying.
Yeah.
Serious money, isn't it?
That's serious money, and they've made statements, including this year, that our bottom line has been affected by the fines, by all the money we're spending on compliance. Of course, others have complained that no, it's also your other underlying operations that aren't doing as well either. Now, the one part of this agreement that I haven't talked about, and I'll come back to the compliance before I end in a minute, they promised in their agreement, 100% cooperation in any investigations of individuals. Whatever you need to know about this conduct, we cooperate. We may not give you attorney-client privileged information. We reserve the right to claim privilege, but aside from privileged stuff, conversations with lawyers, we'll give you anything you need. There have been no prosecutions of any individuals at HSBC. And there were identifiable individuals described in the statement of facts and described in all the emails that came out. Right? How about the people who, when they heard the chief of compliance say, I can't do my job, there is no compliance function that's recognizable, the ones that said you're fired or be quiet, there were people who made those decisions. None of them have been prosecuted in this case. And that was typical, actually. It's particularly true in the Bank Secrecy Act cases. There are typically no individual prosecutions accompanying them. In general, this is actually an update to the book, a short article, more of an essay coming out this next year. I went back to the dockets to see, well, when individuals were prosecuted, only about a third of the time accompanying these agreements. What were the sentences that resulted? What happened to those cases? Even in the third of these cases when individuals were prosecuted, it's typically not high up individuals. It's there are a couple of dozen CEOs, another dozen CFOs, some vice presidents and things, and then a lot of really low-level employees who sometimes argued. There were 2 employees prosecuted accompanying the 2009, the first $1 billion case against Pfizer. And they went to the judge and said, we are 2 of the sales managers at Pfizer. There are 10,000 other people with that title who are all doing the same things that we were doing to aggressively market this drug off-label. There are many, many, many layers of supervisors above us telling us to do it. Why us? we don't deserve to spend years in prison. We were singled out arbitrarily. They just wanted to prosecute someone, and so they prosecuted us. And the judges in both of their cases agreed and gave them no jail time. And no jail time is typical in these cases. More than half of these cases involve no jail time, which is much more than is usual for fraud cases or for comparable categories of federal prosecutions. A lot of these are minor cases and maybe deservingly treated as minor cases. There are also acquittals, and there are few individuals who get deferred prosecution agreements. There are also some individuals who are charged but never prosecuted in the United States because they couldn't be extradited, or there's some that remain fugitives. And so there's some practical obstacles that accompany prosecuting foreign employees of foreign companies. The HSBC case was the case that really got politicians and the public using the too big to jail phrase, particularly since, and I think Senator Warren put it well, money laundering is a crime that there are plenty of people in federal prison in the United States serving just extraordinary sentences for money laundering. The money laundering crimes that accompany the Bank Secrecy Act just have very, very strict sentences. If you take $20,000 in cash and you're a real estate broker or a banker or someone who should know that you're not supposed to take more than $10,000 in cash, and you have some reason to suspect that that money has to do with criminal activity, even though you just think that this might be a drug dealer, you don't know exactly what kind, you're certainly not trying to work with the drug gangs, you just take the money knowing you could serve decades in prison. And so it made a nice political point to say, well, if you launder $1 billion, apparently no one goes to jail. Nothing happens to any person. The bank pays a fine, they promise to make good on compliance, and nothing else happens. In terms of the job of prosecutors, where you think that they're supposed to hold individual people morally accountable, it looks odd. The House Republicans issued a too big to jail certificate based on the monopoly game to the Obama administration. And so we had critics on both sides of the aisle. I think the Republicans loved the chance to say that the Obama administration was being weak on banks, even though they were opposing banking regulation. It was everyone loved to criticize this stuff. There's bipartisan agreement. Now, last summer, this concern was addressed in a speech, and I wanted to end with this. Eric Holder, while he was still in office, gave this little talk. He issued a video statement. It was just as I was finishing the book, and so I was a little worried. This is what he said. I think I had 2 more weeks to edit the book.
There is no such thing as too big to jail.
So there we go. I should have stopped writing the book. And he then went on to say there is no financial institution that is immune from prosecution. Well, immune from prosecution, one would hope that no company is totally immune from prosecution, especially given the legal standard in the U.S. that a company can be prosecuted for the crime of even a single employee in theory. But that doesn't address the concern that prosecutions are settled under terms that may be too lenient, or that don't involve adequate fines, or that don't take compliance seriously, or that individuals that can go to jail aren't going to jail. Lenny Brewer, who was Holder's deputy during the relevant time period, explained, well, HSBC, that was bad stuff, but this isn't a case where they intended to create money laundering. Well, that's not the legal standard either. If they were willfully blind, that is enough. Recklessness would have been enough to prosecute. The people who fired the compliance officer who told them there is money laundering going on, we have no recognizable compliance function. That sounds like willful blindness to me. This isn't a very helpful explanation of why no individuals were targeted.
There was a similar example in Britain with HBOS, where the compliance officer said that the lending function was misfiring of lending money, and he was fired, and nothing's happened. There's been no individual prosecutions or complaint in the HBOS case either.
Well, and U.S. prosecutors may, in terms of prosecuting the company, have sometimes said in these cases, look, these companies are not being prosecuted for foreign bribery, for tax fraud, for sanctions violations. They're not being prosecuted in the UK. They're not being prosecuted in Germany. That's why we're bringing these cases in the United States. Meanwhile, this case was filed in front of a federal judge as a deferred prosecution agreement, and the judge basically said, I'm not a potted plant here. I'm not sure I should be approving this thing. There have been all these criticisms of the agreement. You're not prosecuting any individuals. And he sat on it for about 6 months, making everyone very, very nervous. He ultimately approved it, But he said, I want to know what this monitor is doing. If I'm going to let this case stay on my docket, I want to know that the company is actually showing good conduct. And so I cheered. I've been asking that, judges have authority to approve these deferred prosecution agreements. I think they should use it. And because of that, we know what the monitor has been doing. Normally, we have no idea what these monitors are doing. We have no idea what transpires between the time the agreement is signed and then 2 or 3 or 5 years later when everyone says, we're satisfied, it has been completed, and the case is dismissed. In this HSBC case, we know something at least about what has been happening, and we know that the monitor is unhappy and has been complaining that despite the money being spent, the problems still remain. Meanwhile, there's the question of, well, could HSBC be found in breach? There have been these new whistleblower allegations, all these leaked documents involving Swiss banking. Maybe the prosecutors knew about all that at the time and sort of let that pass, or who knows, maybe the FIFA stuff could count as a breach. U.S. prosecutors, as of this most recent group of guilty pleas, have said that they will tear up deferred prosecution agreements if it turns out the company committed other crimes that it didn't tell federal prosecutors about. But then again, what does it mean if there is a breach, if a company really is a recidivist? What does a recidivist mean when you haven't been convicted? You received a deferred prosecution agreement. You have no record of the company. The bank that had its agreement torn up just pleaded guilty instead and paid a small additional fine. They received, a settlement part 2. It's not clear what exactly that means. So maybe HSBC is still molting or still in the process of changing as a bird. But I hope...
Sorry, just to say, you say that HSB is changing as a bird, but it's a flock. HSB is not a bird.
Well, that was part of the problem to begin with.
Yeah.
That I met one of the lawyers who helped to create HSBC's compliance function in the late 80s, when maybe it was a bird. It was a single bank, and all of a sudden it expanded, in the 90s to involve subsidiaries far-flung all across the world, and it never had a centralized compliance function. To build that from scratch really is a serious undertaking.
And I think that's where this sort of monitor function is actually trying to process re-engineer a whole bank.
Well, and the bank is doing it on its own, supposedly, too. I certainly understand why this is a 5-year agreement and not the typical 2 or 3 years. But there's an open question. Are these prosecutions useful catalysts for improving corporate compliance? Do prosecutors themselves have anything to add? Do they have any idea how to accomplish a task like that? Are they at least good at hiring a monitor that can help with the process? Does the involvement of regulators make anything better?
And how does it relate to franchise re-engineering? Because if you're changing the compliance function, you're also changing the franchise quite substantially.
There's another lingering open question. I tried to collect what information I can about these cases and describe what has changed about these prosecutions. Throughout, federal prosecutors have said that one of our goals is not just to fine, but it's to actually reform these companies. That's why we're giving them deferred prosecution agreements. We are trying to rehabilitate corporate offenders. We have no idea in some areas what really makes compliance particularly effective. Now, there are some violations that are cut and dry and are easy to fix, but you'd think in cases like that, then you don't need to prosecute the company. You can prosecute the employee, and the company will install the video camera so the employees don't take the cash out in the open anymore. If it's something as simple as there are illegal emissions because the meter was broken, so fix the meter. But anti-money laundering programs, what makes those effective? Well, certainly if you have no real compliance staff, that's really, really bad. But the difference between a medium to good compliance program for anti-money laundering, a big bank like that will generate, hundreds of thousands, if not millions, of transactions that automated systems can flag as raising potential problems. And then you need people to read them. They can't read all of them. They can read some of them, and then do something to follow up on the important ones. How do you decide whether a system like that is a really good one or not? Knowing full well that some sanctions that violate the laws of the United States and maybe other countries as well will absolutely escape review, and that it's inevitable that some will. Same thing with foreign bribery and reviewing transactions to make sure consultants aren't being given money on the side because they happen to be know relatives of foreign government officials and can grease certain wheels. All the paperwork can be filled out fine in a way that evades compliance programs. And so some of these monitors talk about the need to bring in a culture of ethics into a company and to focus on not just ethics but integrity when one is trying to reform a company that has been prosecuted. What that means is something maybe for organizational psychologists, but I don't know what it means. And certainly prosecutors don't. And so these are not easy cases. They're really big and important cases. And I do think that U.S. prosecutors have taken on something incredibly ambitious over the last 10 years. And they've absolutely changed the way that corporate prosecutions are brought in the United States. They've started to change the way that corporate prosecutions are brought around the world. And so the UK has passed a bribery act modeled on the Foreign Corrupt Practices Act. The UK now has a statute permitting deferred prosecution agreements. There's no statute like that in the US, it's all informal. Other countries have adopted corporate crime statutes increasingly, mostly in particular areas, no general corporate criminal liability like in the US, but particular antitrust or foreign bribery crimes. And so there's more of a movement. Other countries figure, well, the $1 billion fines could be paid in our country and not to the U.S. Treasury. Maybe if we bring the cases ourselves and we show that we are serious about enforcement, then there won't be parallel prosecutions around the world. And U.S. prosecutors have said we absolutely want to credit countries that are doing the enforcement on their own. But whether all of this movement towards greater corporate criminal accountability actually improves the behavior or even ethics of companies, no one has any idea. And nor would companies typically want to cooperate with researchers and generate data that could help to assess which compliance programs are working. That would not be a useful thing for most companies to do, although it would be really interesting for people like me.
Should we throw it open?